Well, first let me say that I am confident that I never sent nor received any information that was classified at the time it was sent and received.
From the group of 30,000 emails returned to the State Department in 2014, 110 emails in 52 email chains have been determined by the owning agency to contain classified information at the time they were sent or received. 8 of those chains contained information that was top secret at the time they were sent. 36 of those chains contained secret information at the time, and 8 contained confidential information at the time.
Personal emails are my personal business, right? So we went through a painstaking process and turned over 55,000 pages of anything we thought could be work-related. Under the law, that decision is made by the official. I was the official. I made those decisions. And as I just said, over 1,200 of the emails have already been deemed not work-related.
It's also likely that there are other work-related emails that they did not produce to State and that we did not find elsewhere and that are now gone because they deleted all emails they did not produce to State, and the lawyers then cleaned their devices in such a way,
what, like with a cloth or something? I don't know.
As to preclude complete forensic recovery.
I understand why different agencies have different views, and I respect that. It does not change the fact that I did not send or receive any information that was marked classified at the time.
Although we did not find clear evidence that Secretary Clinton or her colleagues intended to violate laws governing the handling of classified information, there is evidence that they were extremely careless in their handling of very sensitive, highly classified information. For example, 7 email chains concern matters that were classified at the top secret special access program at the time they were sent and received. Those chains involve Secretary Clinton both sending emails about those matters and receiving emails about those same matters.
I did not send or receive any information that was marked classified at the time.
There is evidence to support a conclusion that any reasonable person in Secretary Clinton's position or in the position of those with whom she was corresponding about those matters should have known that an unclassified system was no place for that conversation. Although there is evidence of potential violations of the statutes regarding the handling of classified information, our judgment is that no reasonable prosecutor would bring such a case. Prosecutors necessarily weigh a number of factors before deciding whether to bring charges. There are obvious considerations like the strength of the evidence, especially regarding intent. Responsible decisions also consider the context of a person's actions and how similar situations have been handled in the past. In looking back at our investigations into the mishandling or removal of classified information, we cannot find a case that would support bringing criminal charges on these facts. To be clear, this is not to suggest that in similar circumstances, a person who engaged in this activity would face no consequences. To the contrary, those individuals are often subject to security or administrative sanctions, but that's not what we're deciding now. As a result, although the Department of Justice makes final decisions on matters like this, we are expressing to Justice our view that no charges are appropriate in this case.
I don't know why that's funny. I mean, did you have any in-person briefings? I don't find it funny at all.